James Madison said that with respect to the atmosphere, that it is the breath of life. Deprived of it, they all equally perish, referring to man, plants, and animals. And we have abundant evidence going back to the time of the founding that our nation's founders understood deeply that survival resources, including our soils and our atmosphere, were fundamental to our liberties. And this is part of the constitutional story that we're telling in this case. And then if you would move to the next slide. This is just an example of the kind of systemic and structural remedy that we're seeking in the case. We are looking to past cases in the realm of desegregation and prison reform and treaty right enforcement here in the Pacific Northwest, where governments have been required to prepare plans for bringing systems that are unconstitutional into constitutional compliance. So the thing I would offer to you, just in concluding, is we have an energy system that's powered by fossil fuels that is destroying the foundations of life. And that system is unconstitutional. And so the job of the federal defendants in this case, with a court order, is to bring that system into constitutional compliance by enacting policies and a plan that will move us off of fossil fuels and increase the sequestration capacity of our nation's soils and forests. And you can go to the last slide. So our next court date will be a Ninth Circuit oral argument the week of June 4th. And hopefully we'll have a decision on our injunctive relief motion. And we're pushing hard to get back to trial as soon as possible. So that's my update. I think I've used all my minutes. Is that right?
You have 2 more if you have more to say.
Oh, I have 2 more. So just since I won't be part of the discussion, the one thing I would add, based on I know what some of the discussion will be about, is climate litigation and this constitutional litigation it's very important for public awareness, for movement building, but that is not why we're doing this. We have clear evidence from our experts and from government documents that there is a clear constitutional violation happening and being perpetuated by our government's role in perpetuating this fossil fuel energy system. And so the ultimate goal is really to seek that kind of transformative relief that we've seen at other moments in history when people have been discriminated against in such profound ways. And here, it's really children, it's the youngest generation and all future generations that are being treated unfairly and being discriminated against by the people in power today who are perpetuating this crisis. And with that, thank you so much for listening. I hope you have a really engaging discussion and look forward to connecting with people again soon.
Thank you.
Thank you.
So thank you to Julia. We're going to move next to Dina Adler, who's going to broaden the scope back to give us an overview of what's going on in the courts. Dina is a climate law fellow at the Sabin Center for Climate Change at Columbia Law School. Her work at the Sabin Center includes tracking U.S. and international trends in climate change litigation. She is a Yale alum, so she's returning home here, having completed both her JD and a Master's of Environmental Management here at FES and, of course, the JD at the law school. After Dina, we'll move right to Danielle, I'm going to say it wrong, but Andrade Morera? Is that somehow close? I apologize. Danielle teaches at the Pontifical Catholic University of Rio, and she is also coordinator of a research group, Law, Environment, and Justice in the Anthropocene, and the director of the Law for a Green Planet Institute, humbling all of us. She holds a PhD and Master's of Law from the State University of Rio. And after Danielle, further broadening our global reach here, we have Gabriela Eslava, who leads the group of 25 young plaintiffs who filed the first climate change and future generations lawsuit in Latin America. She is a researcher at the Center for the Study of Law, Justice, and Society, a Colombia-based think tank, also a lawyer who graduated from the Universidad de los Andes. Thank you. Dina.
All right, good afternoon, everyone. I want to thank the organizers for all of their dedicated efforts to make everything run and bring this conference to fruition. It was always a delight to be here as a student, and I'm equally happy to be back here talking to you guys about climate change litigation this afternoon. We've heard at numerous points throughout the day that we're really at a moment of climate crisis. That's not a shock to anyone in this room. We have a closing window of opportunity to really ratchet down our greenhouse gas emission trajectories. And we don't have the law and policy on the books that we need to drive those greenhouse gas emission reductions right now. And that situation may have, in part, be what drove The Guardian to title an article on climate change litigation last year with a somewhat desperate question. Can the court save the world? So I'm not sure that we're going to be able to answer that lofty of a question today, but hopefully we're going to spur some thought as to how the courts can deliver climate justice and what sort of limitations they come up against. So as Marianne mentioned, I'm going to try to kind of back this up and give you the 30,000-foot landscape level view of some of the trends in climate change litigation. And I'll touch a little bit on the international scope, but try to focus mostly on trends in the US during the Trump administration. So at the Sabin Center, we have an international climate change litigation database. There are 1,278 climate change cases in the database and counting. So these are cases that raise climate change as an issue of fact or law. Arguably, many more cases affect climate change. And as you can see, about 1,000 of those cases are in the US, though there are also concentrations in Canada, Australia, throughout Europe, and just a smattering in Latin America, Africa, and Asia. And these cases shape climate change law and policy in a number of ways. A lot of these cases try to tie resource extraction to climate change. There was a recent victory in Australia just a few weeks ago in which the courts upheld the government's denial of a construction permit for a coal mine and cited climate change impacts as part of the logic behind the agency's decision and that being legitimate. There are also this wave of cases now that are seeking to hold governments accountable for their climate change mitigation and adaptation commitments. And some of those make the novel arguments that look beyond statute and try to establish the right to a healthy environment, the right to a stable climate system. And these cases, as my colleagues will discuss, are an amazing part of the effort to advance climate change justice. There are additionally a number of cases that try to make a very difficult emissions-related causation argument and hold fossil fuel companies accountable for the harms, the climate change-related harms of their products. And a few cases now that are seeking to look at potential liability for the failure to adapt. So government entities and companies that put citizens at risk by failing to consider climate change and adapt accordingly. So I want to spend most of my time discussing trends in US climate change litigation during the Trump administration. I produced a report for the Sabin Center last year that looked at all of the climate litigation filed during the first year of the Trump administration. And the cases that I analyzed in the database met the following criteria. They raised climate change as an issue of fact or law. They were filed in 2017 or pivoted significantly in response to deregulation activities by the Trump administration in 2017. And these are national level cases. They raise questions of federal law or national climate policy concerns. So these cases fell into 5 major categories. And 4 of those categories, represented by the blue wedges, are what I'm calling pro-climate protection cases. So they either uphold or advance climate protections. And the orange wedge there represents cases that work against climate protections. So seek to support climate deregulation, undermine climate protections, attack climate protection supporters. So the courts can be used both ways. They're a tool. And as you can see, the pro cases outweigh the con cases 3 to 1. And to dig a little more deeply into those, starting with the lightest blue wedge in the top right, about 17% of the cases concerned defending Obama administration climate change policies and decisions. A lot of these concerned the Trump administration's attempt to delay Obama-era policies from going on the books. These were largely found to be, the ones that have been decided thus far were found to be illegal, or that the administration was acting illegally. So some of those rules concerned limiting methane emissions, energy efficiency standards for appliances. There are also lawsuits that directly went after the Trump administration for trying to open up areas of the Arctic Ocean that were previously protected to fossil fuel development. And then about 15% of the cases, the next wedge, were concerned with promoting transparency and scientific integrity from the Trump administration. So these are largely Freedom of Information Act requests. So they're seeking government communications and records, and they were trying to shine a light on potential illegal or unethical behavior by the Trump administration. Also exploring what was the basis behind statements of climate denial or suppression of science. Then the third category, the largest category that concerned 28% of the cases, represents an ongoing trend that's been going on prior to the Trump administration, and that's integrating consideration of climate change into the environmental review process. So under the National Environmental Policy Act, when you have a major federal action affecting the environment, you have to do an environmental review. So this gets to how you have to consider greenhouse gas emissions and climate change impacts of particular projects. And there are also in this category cases that involve the Endangered Species Act and other environmental statutes. The fourth category are these cases that advance or enforce additional climate protections beyond what we have on the books, what we want to see if we're trying to promote climate justice and go further. So, for example, you may have seen in the news some of these innovative suits by a number of cities and counties in the state of Rhode Island to hold fossil fuel companies accountable for the climate-related harms of their products and seeking damages from those companies for how climate change is impacting the citizens of those government entities. And then this fifth category, as I mentioned, the cases that are working against climate protections. These are largely filed by industry, though some by subnational government entities and NGOs. The pro cases are largely filed by NGOs, cities, states, and tribal entities. And in most cases, the federal government is the defendant in these suits, and they're looking most often under environmental statute or administrative law to find obligations of the federal government that aren't being fulfilled, though there are also some novel issues raised under constitutional law and tort law. These cases span a variety of sectors, so there are a lot of ways that climate change litigation can advance climate change justice. And I think that's one of the things I wanted to drive home with this report is there are there's luckily a number of major cases that we track in the news, but there are incremental decisions happening all the time that shape climate change law and policy. So the sector by far of the most cases was the fossil fuel extraction and transport sector. But then the second largest volume of cases were these Freedom of Information Act suits that were seeking government records and communications that go across a bunch of sectors. And then impacts on land, water, and wildlife was the third largest category. And then as you can see, there's a number of suits affecting major greenhouse gas emitting sectors. So suits concerning rules around limiting emissions from vehicles, from power plants, energy efficiency, and appliance standards. So takeaway is there's many ways that the courts can affect climate change law and policy. So a couple of ways that then these cases are proactively being used to advance climate justice well and where they meet some challenges. The deregulation cases are a place where the courts, I think, really can work to advance climate justice and be used well. This pie chart is from the Institute for Policy Integrity at NYU and is looking more broadly at suits regarding Trump-era deregulation in the courts. And the government has lost in 28 out of 30 of those suits thus far, and those are not representing necessarily final judicial decisions. So some of those cases are still in progress, but at least lower courts have found a lot of those activities illegal. About 10 of those cases concern climate change. So the courts do a good job of upholding the rule of law and the rules of administrative law, but they don't necessarily guarantee a substantive climate victory. So for example, in a number of these rules related to climate change, regulatory rules, the court has said the government couldn't illegally delay these rules in kind of a haphazard manner, but that doesn't stop the agencies from going through the legal process of notice and comment rulemaking, which takes months, if not years, and trying to withdraw, repeal climate protections issued by the Obama administration, or to replace those rules with more watered down rules that don't protect the climate as well. So we're seeing the agencies do just that now that they've lost these delay cases, and there'll be another wave of lawsuit challenging those finalized rules when they're ripe for legal action. So a way that, the fun way to think about how the courts advance climate justice are these kind of novel suits to advance additional climate protections. And Julia already talked a bit about the public trust litigation that's happening in the US. There are also suits under regulatory and statutory law seeking to compel additional climate protections from the government, so digging into the weeds of the Clean Air Act. And then, as I mentioned, there are these novel suits, tort lawsuits against, and other common law claim suits against fossil fuel companies for damages. And there are 14 municipalities and counties right now, as well as the state of Rhode Island, who have filed litigation against these fossil fuel companies, saying that they knowingly continued to produce these products, knowing that they had these climate-related harms and deliberately misled the public, and are now seeking damages. So there have been some initial dismissals of these suits in federal court, and those have both been appealed. There are a number of decisions still pending, including at state court, and it is a bit of an uphill battle. These cases really push the envelope in what can be done, but thank you. They're important regardless of whether they win and lose to a certain extent, because they shape the public opinion. And you can see already a reaction to these suits. Exxon has started lobbying for carbon pricing policies and mechanisms in exchange for liability from these suits, in exchange for being exempted from liability from these suits. It'd be pretty perverse the other way around. But I think that's something it sounds like we'll get into more during our discussion, that there are ways that litigation can be effective, win or lose, in shaping the public discussion. And even if these cases advance to discovery and bring a bunch of documents to light from these companies, that could be hugely effective. And the tobacco litigation had many losses before it resulted in a victory. So these battles can sometimes go on for a number of years, and it takes time to kind of change the law on the books and move through the courts and co-shape social movements, as Marianne spoke about. So I think I'll leave it at there for the moment, and thank you.
Well, good afternoon to everyone. It's a pleasure and an honor to participate in this conference. I'd like to thank the NDEL team for inviting me to share some thoughts with you today. I have some notes here, so they help me with the English. I'm here to talk with you about the topic of climate justice in Brazil. So my view is specifically in Brazil, and the tools we have already to fight climate justice. I must confess I have mixed feelings about this task. On the one hand, I feel enthusiastic. I'm glad to present the main features of Brazilian environmental law, and above all, the level of development reached in this relatively new and vibrant area of law, in terms of legislation, doctrine, and case law. All this progress shows that we have strong legal tools already available for dealing with climate issues. On the other hand, we are currently faced with perspectives which make me feel uneasy. Firstly, we have been watching the dismantling of the political and administrative structures related to environmental and climate issues. In addition, we have been watching, there are worrying trends of significant legislative setbacks. Will Brazil walk backwards and reverse all the progress achieved with its environmental policy instruments? I hope not. Although the current scenario is not the most encouraging, I am intentionally maintaining my optimism in pointing out some of the traits of Brazilian law and possible litigation strategies for fighting climate change. I will begin by showing you a quick overview of Brazilian greenhouse gases emissions and the legal framework specifically related to the climate. Then I will address just one of the multiple legal tools we have and we can use as part of climate change litigation strategy. We are going to take a look at the main features of civil environmental liability in Brazil and its potential to help fostering climate justice. I'm not going to follow these slides word for word, but they contain some information, some reference that may be useful afterwards on the topic of climate litigation in Brazil. Well, Brazil is among the 7 major emitters of greenhouse gases in the world. Around 70% of Brazilian emissions are from land use change and agriculture, crop and livestock. 21% of our emissions come from energy production and consumption. This data shows the main patterns of our greenhouse gases emissions and the associated challenges. We are party to the Paris Agreement and have since 2009 a national policy for the climate change that provides principles, goals, guidelines, and instruments to fight climate change. It's not an easy task. Oops. Well, we have one slide missing here. Maybe we had some problem, but that's okay. It's not an easy task to enforce a climate policy. Due to its unique characteristics, we can describe climate change as a super wicked problem. The challenge is to develop and implement climate-related laws and policies highlight the litigation potential to address climate change and its impacts. The UN provides in its 2017 report an interesting overview on global climate litigation status, describing its trends and the main legal issues in dispute. And the Sabin Center wrote this report together with the corporations. As we can see, now we have the slide, Brazil does not appear on the map yet. It appeared in a more recent map with 4 cases. But anyway, in fact, we still don't have any special relevant litigation that specifically relates to climate change. While many cases in Brazil deal with environmental issues, climate is so far a secondary concern in the courts. Those 4 cases that appear, they are related to air pollution, deforestation, and other associated issues, but not specifically related to climate change. Despite that, these cases may raise powerful topics for the climate change discourse. For example, they might help to address the controversies related to causation in response to what was highlighted in the UN report as trends in climate litigation. And because of such trends, I'll make a few general observations on Brazilian environmental law before focusing on our civil environmental liability in its main features. What I want to show you is how and why this legal tool has great potential in promoting climate justice as a result of the equal distribution of social environmental benefits and burdens that it provides. And here comes the climate justice and the social environmental justice, more specifically. There is a quote attributed to the German philosopher Arthur Schopenhauer, according to which all truth passes through 3 stages. First, it is ridiculed. Then it is violently opposed. And finally, it's accepted as self-evident. It becomes commonplace. George Bernard Shaw expresses a similar idea when he says that all great truths begin as blasphemies. In the recent decades, and for many reasons, Brazilian environmental law has become a testimony to the truth behind these quotes. In fact, most of the traditional legal tools we are actually inadequate to face the challenges of contemporary society, and especially the complexities and peculiarities of environmental and climate demands, like a super wicked problem. The current threats to the planet, climate, biodiversity, water, air, soil, and human health, all these elements related to each other within a holistic approach, have today a scale and intensity never recorded before. Climate change appears in this multifaceted context, raising diverse complexities. Therefore, the development of legal theses and tools to environmental protection often depends on the questioning and rupture of long-established legal structures. And it's for this reason that environmental law has come to be considered a subversive area of law. It causes, and it must cause, real disruption. The first relevant legal response to this unprecedented challenge is the recognition of the right to the environment as a fundamental right. It is a third-generation human right. As you can see, the Brazilian Constitution provides for a collective right to a balanced environment. At the same time, it sets forth the duty of the same collectivity and the public power to guarantee conditions to a healthy quality of life. Besides, the right to a balanced environment expressly reaches future generations, to which the present generations have duties and bonds of solidarity. Our Constitution also prescribes three different and independent types of environmental liability: civil, administrative, and criminal. In Brazil, the obligation to repair environmental damage has constitutional grounds. Civil liability here is understood from a rather comprehensive perspective. In addition to its specific function of promoting reparation and compensation for damages, it also has an indirectly preventative role. It induces standards of care so that the harm does not occur in the first place. Moving to civil liability specifically, I would say that we can address environmental harm, including those that occur because of climate change, from the perspective of negative externalities. As we know, the concept of externalities was first addressed by economists. It gained ground in the law with the polluter pays principle. Usually, economic agents tend to keep the fruits or profits of their activities for themselves and to share the burdens and losses with society. In response to the unequal scenario where costs are socialized and profits privatized, the polluter pays principle imposes the duty to internalize negative externalities. In other words, the polluter has to bear, even the potential polluter, has to bear the costs and measures to prevent and to repair environmental harm arising directly or indirectly from its activities. This goal of promoting distributive environmental justice and climate justice may be achieved with the help of civil environmental liability. The Brazilian National Environmental Policy, enacted in 1981, established a series of premises for environmental protection. Among these legal provisions, I want to highlight some that are specifically related to the duty to repair environmental damage. First, civil liability for environmental damage in Brazil is strict. It's applied regardless of fault on the part of the polluter. In other words, liability is imposed regardless of an intent to cause harm or a breach of a duty to exercise reasonable care. For civil liability to be applied, it is enough for the following elements to take place: the environmental damage, the conduct, an act or omission, and the causation. In addition, the Brazilian scholars and the Superior Court of Justice widely accept the so-called full risk liability. According to this theory, typical defenses based on the intervening causes, such as third-party conduct or acts of God, whether or not foreseeable, are not admitted. Whoever creates a risk of damage to the environment and third parties due to its mere existence may be held liable if such damage occurs. We also have a far-reaching concept of causation in Brazil. The notion of causation is not explicit in the law. We can understand what causation is with the reference to the legal definition of polluter. Under the Brazilian national policy, the polluter is the party directly or indirectly responsible for an activity that causes environmental degradation. Therefore, when we are dealing with environmental damage, causation has a really comprehensive scope. For instance, according to this ruling from our Superior Court of Justice or High Court of Justice, anyone who falls within a vast array of conditions may be held liable, not only strictly, but also jointly and severally. This would include, for example, those who finance or benefit from others' activities. Thus, in Brazil, the liability for environmental damage is not only strict, but also joint and several. This understanding has two main grounds. One, the comprehensive definition of polluter, and two, the Brazilian Civil Code, according to which joint and several liability is to be applied when several parties have caused a single harm. Another important feature is our concern regarding the full reparation for environmental harm. The damage to be repaired and or compensated covers not only the ecological damage involving fauna, flora, air, water, and soil. It also includes cultural, social, and economic aspects. We must also consider individual and collective harm, including material and moral damages. To finish, the Brazilian Court of Justice recently recognized the shifting of the burden of proof as a comprehensive and binding rule applicable to all civil lawsuits involving environmental damage. This ruling consolidated the understanding that the defendant should bear the burden of proving that there's no harm or they're not responsible for the damage. Based on these features, I guess that there's nothing more severe and comprehensive than the rules applied to civil environmental liability in Brazil. And they are all, at least in theory, applicable to those who contribute or give cause to climate change. To conclude, I would like to say that most of the disruptions triggered by Brazilian environmental law in the last decades, after causing astonishment, followed by opposition, ended up accepted by the Superior Court as consolidated theses. I believe the same may happen with climate litigation if we can resist the wave of regression that threatens Brazil. Each and every aspect of the subject matter presented here today were once regarded as legal blasphemies. Perhaps in the near future, they will also become commonplace for fighting climate change. Then we, as a society, shall be in a better position to achieve climate justice. Thank you.
Good afternoon. I want to start by thanking the organizers of this conference for the opportunity to share with you the Colombian experience on climate change litigation. I want to thank especially Camila Bustos, who's not only one of the co-organizers, but who's also one of the researchers behind the case I'm going to present today. Many of the things that I will mention today and the concepts that mark the Colombian case have been profoundly shaped and marked by the concepts we have heard throughout the conference today. My presentation is going to have one specific feature, the fact that I'll be presenting from two different points of view. On one hand, I'll be presenting as one of the lawyers behind the first climate change and future generations' rights lawsuit in Latin America. On the other hand, I'll be presenting as one of the plaintiffs, and I will go back and forth between these two roles whilst telling you how we built this case. This lawsuit was born from a reflection on how Colombia is going to be like for future generations. 3 years ago, the Colombian government signed a peace agreement with the FARC guerrilla, the oldest guerrilla in Latin America, ending a war that lasted more than 50 years. And those who are children today are the first generation of Colombians who are going to live in peace. So how is our country going to be like in a peaceful context? Are we going to live in harmony with nature? We started our research on climate change by looking for the main drivers of greenhouse gas emissions. To our surprise, Most greenhouse gas emissions didn't come from public transport in our overcrowded and polluted Latin American cities, but most drivers were located in the most biodiverse region of the world, the Amazon rainforest. Here you can see the points where most fires have taken place in the last months. In 2016, deforestation increased by 44%, meaning that a total amount of 178,000 hectares was cut down in 1 year. That represents half the area of Long Island. The reason behind this trend is that areas previously difficult to access, especially because of the armed conflict, are now beginning to be colonized. You could say that is like a paradox that comes with peace. How is it possible that armed conflict protect our biodiversity? On its own, deforestation contributes to 36% of the country's total greenhouse gas emissions. We also found that 20 years from now, we will have to live in a country 1.6 degrees warmer due to climate change, according to official documents. The problem is that cutting down the rainforest does not only contribute to climate change-related impacts, such as melting of glaciers, temperature increase, and the spread of vector-borne diseases, but it also alters the water cycle. This in turn generates serious threats of floods, droughts, landslides, as well as less access to water and food resources. Moreover, given that all ecosystems are interconnected, deforestation in the Amazon does not only affect those living in that region, but also elsewhere in Colombia. For example, the rain produced in the rainforest travels and moves with the wind, and when it reaches the Andean mountains, it becomes the water that almost 70% of Colombians drink every day. We wanted to present climate change as a human rights problem. Regarding this problem, the Colombian government has not completed at least 4 national and international commitments. First, Colombia ratified the Paris Agreement, which includes a commitment to reduce greenhouse gas emissions. Second, the government also failed to fulfill a joint statement between Colombia, the United Kingdom, Norway, and Germany to reach zero net deforestation by 2020 in the Colombian Amazon. Third, the government failed or disregarded our national constitution that establishes the right to enjoy a healthy environment. And last, it also failed to fulfill a commitment included in our National Development Plan to have deforestation rate lower than 90,000 hectares. So the plaintiffs of this legal action are children, teenagers, young adults that come from 17 different cities and municipalities of Colombia that are highly vulnerable to climate change and who are between 7 and 27 years old with an average life expectancy of 78 years. This means that the plaintiffs will develop most of their adult lives in the first period or the first climate change scenario between 2040 and 2070. We share a collective reality, and I include myself in this part. We are the first generation that will face the greatest climate-related impacts. We are the first generation to live peace in our country, but we are the ones who are going to suffer the most the effects of climate change. And we are not taking decisions about our future. We argue that current deforestation rates and the government's failure to act are violating our right to enjoy a healthy environment. The destruction of the Colombian Amazon is not only having impacts on national ecosystems, but is also increasing greenhouse gas emissions and thus exacerbating climate change. That threatens at least 4 fundamental rights: the right to water, the right to food, health, and life. We choose to file a tutela action. That's a special mechanism under the Colombian National Constitution that for individuals to demand the protection of their fundamental rights. Through this lawsuit, we claimed that the Colombian government and the competent authorities failed to fulfill their duty to protect the environment. Specifically, the lawsuit was demanding the protection of the fundamental rights of future generations. We were fully aware that what we were saying the judge was not a traditional case on environmental damages. We had to prove that the plaintiffs who lived in the north part of Colombia had legal standing for something that was happening in the south area of the country. Most of the evidence we provided came from studies made by the government itself. We knew that climate change has multiple causes, not only deforestation. But what we were trying to say or to prove is that fighting the main cause of greenhouse gas emissions in Colombia, meaning deforestation, would deeply help to solve the problem. Therefore, we asked the judge to read our lawsuit with some special lens. We asked the judge to take into account 5 principles that have been in all the treaties that Colombia has ratified and also in our national constitution. The principle of solidarity, meaning solidarity between people, but also solidarity with all the sentient beings that inhabit the Amazon rainforest. The precautionary principle, the best interest of the children, intergenerational equity, and participation. We asked the judge 4 things. First, to guarantee the rights of future generations to enjoy a healthy environment, life, health, food, and water. We asked to formulate an action plan to reach zero net deforestation in the Colombian Amazon. We also asked for an intergenerational pact for the life of the Colombian Amazon and for the municipalities of the Amazon to update their land management plans. We lose before the judge of first instance. We appealed, and our case got to the Supreme Court of Justice. And when in the court, the judge decided that the principle of solidarity was the base of the case. What basically the judge said that if we think of the idea of the other, understanding by the other not only people, but also nature, and if we understand ourselves as part of nature, then we should guarantee the rights of those others that share our planet. So that was the base the judge used to recognize the future generations have the right to enjoy a healthy environment, but also to recognize that, or to declare that the Amazon rainforest is an entity subject of rights, entitled of protection, conservation, maintenance, and what is more important for me, restoration. Next April is going to be a year since the Supreme Court made its decision on this case. Now the big question for us as plaintiffs and as the lawyers behind this lawsuit is how to guarantee that the Supreme Court's decision in favor of 25 youth does not just stay on paper. We wanted to show that climate change has a face, the face of today's children who are relatable and who are now demanding intergenerational justice. We wanted the government to take into account the voice of the youth when deciding about their future. So that's the story of the first climate change lawsuit in Colombia. Thank you.
So thank you all. Can you hear me? Okay, I'm going to start the questions with a couple of openers. And this one is really pitched to anyone on this panel. And I'm going to take the liberty of asking this question because it is a panel about litigation and it's sort of a picky question. But we understand that climate change intrinsically raises issues of climate justice. But climate change is not the same, it's not interchangeable with climate justice. And so in addition to litigation
to focus attention or to address climate change, are you seeing attention in the courts to issues specifically of climate justice? For example, the particular impacts of climate change on the most disadvantaged in our society. Or thinking about this question another way, what is the role of the courts in addressing the specific issues of climate justice? Or do you see those as interchangeable and just disagree with me? Who wants to take a stab?
Now it's okay. Well, actually in Brazil, I would say that we still don't have a specific focus on climate justice, although we have been discussing what we call social environmental justice that has the same grounds of climate justice, but don't take into account specifically the climate issues. But we can find climate issues in what we call social environmental justice in Brazil. And I would say that the courts are still not yet taken into account those worries regarding climate justice, regarding social environmental justice. We're still beginning and discussing. But one thing that calls my attention, I think it's not enough, but can probably help in this discussion and fostering this discussion, is looking at the polluter pays principle and its potential and its purpose to induce the internalization, the equal distribution of burdens and profits, costs and benefits. And I know that it's not a common understanding. Not everyone agrees that the civil liability is a tool for implementing the objectives of the polluter pays principle, but taking into account that it can help promoting this equal distribution of social and environmental burdens and profits. I think that civil environmental liability has a role to play, important role to play regarding climate justice and regarding before that, like we are seeing in the courts there, environmental justice.
What about that? Is polluter pays part of the answer? Are there other approaches that you see either now or could see in the courts to address climate justice?
Thinking on your first question, I would say that from Colombia and from domestic judges in Latin America, this is something new. They're very used to more traditional environmental cases, and climate change, although I feel like they are not deniers, at least in Colombia, they don't know the evidence. There's lots of information. I think this is a moment in history where we have evidence for almost every damage related to climate change. And judges are starting to learn how to read that as evidence on their cases. So I think that for them, climate change and climate justice right now feel like almost the same thing, but I think they're learning, and maybe a decade from now, they're going to have enough learning to say that they're different.
I'd say, chiming in on the first question as well, I think it can be really frustrating to have to look at how climate justice gets integrated into the courts. If I think about the Juliana case, and that really seems to speak of climate justice. There's something very appealing about the youth plaintiffs asking the government to do more to protect their future, or these municipal suits and the suit by the state of Rhode Island against fossil fuel companies for the damages related to their harms. Like, when I think of those cases, I think of justice. But there are a lot of legal barriers sometimes to raising those sorts of more novel legal claims. There was a suit, Clean Air Council v. United States, that was dismissed recently, that there were some youth plaintiffs from Pennsylvania who are saying that their asthma was worsened by climate change, and the judge ruled that they didn't have standing, that their injury wasn't particularized enough and eminent. So I think those sorts of cases, it can be very frustrating sometimes to see how climate justice seems to be stymied by the courts. But I mean, that's where I think sometimes you have to look to the broader role in these cases in advancing an argument and putting those questions of climate justice in the public forums and talking about those, and still look to the broader scope of climate change litigation to use the tools and the frameworks that we have to try to advance climate change law and policy incrementally through a whole variety of environmental statutes as well.
Well, just following up on that, Dina, you mentioned standing and the problem getting some of these issues in front of the courts. Earlier, we heard about and know about the politics in Brazil, and of course the allusion to the politics here, and the rise of climate deniers. Are those the biggest challenges we face, or what are the greatest challenges in making meaningful progress through the courts, and how do we overcome them in 30 seconds or less? Anyone want to take a stab?
I think that Dana said before, bringing those cases to courts can help shaping the public opinion. That's one important. It's not an obstacle, but it's something that we can. It's a positive view of the trends, of the possibilities we have, and also I think that we can put pressure on stakeholders, public or private, and foster meaningful discussions. I think it can, when we're not talking about taking some issues to court, they probably start to be dealt by those stakeholders with another importance, with another view, another way of viewing.
I think that those are absolutely barriers, questions of standing, but Professor Kaiser has an article talking about how tort law can act as a prod and a plea, and I think you have to think about sometimes the law won't shift unless we prod it, and even if we don't shift the decision, as we've all been kind of discussing, you can shape the public perception, and maybe a case goes to discovery and reveals documents that lead to other lawsuits, and it's an incremental process, but hopefully, I think Professor Harold Coe also likes to quote Martin Luther King when he's talking about these climate change cases, and the arc towards justice may be long, but it ultimately bends towards justice. So I'm paraphrasing a little bit. So it takes time, but we have to try to prod the system in order to get the change we want to see.
The arc of the moral universe bends toward justice.
Thank you.
Do we have some hands? Okay, and actually let's do a little bit of a cue. A couple more hands so we can get the microphones going.
Primero, Claudia, gracias por todo lo que tú estás haciendo y representar Colombia. In English, thank you, Claude. Did I just call you Claudia? Oh my God. Gabriela, for all the work that you're doing. It's really important to me and my mom as Colombians that you're doing this. And my question for you is, I guess about how we as organizers in the United States and other places can draw more attention to the work that Latin American youth and youth in the global South are taking, because when you first told me about this last night at dinner, I was appalled that I, as a Colombian climate activist heavily involved in the movement, had not even heard about it before. And all these strikes in Europe are being covered, and the European kids, European kids take action and the media is all over it, but Latin American kids take action, and I haven't really seen any media in the United States. So I really want to help spread this to the United States and raise awareness, especially as someone, when they ask, oh, where's your family from? I say Colombia. They're like, oh yeah, that's with the drugs, right? They don't think about Colombia as anything more than just a bunch of cocaine. And people have even asked my mom, oh, do you grow drugs in your garden? Which is horrible. They literally asked her that if she gives me, that stereotype is horrible. And I guess I'm rambling, but my question is, how can we help let the world know what Colombian kids and Latin American kids are doing, and that it's not just the European kids, but it's also kids in the global South who are taking action, and how can we get media and help you? Because I really want to help you.
Thank you.
Well, thank you for your question and for your interest in our case. I feel like this is part of a global problem. Deforestation is not happening just only because the armed conflict ended, but also because the main drivers of deforestation are related also to the crops of coke. So we need to start thinking how each and every country is contributing to deforestation and how the drug traffic is also affecting the Amazon rainforest. In the national treaties, we also think about the Amazon rainforest as a very important ecosystem for humanity. But it seems like when it's time to protect, we tend to forget and we leave that problem to the countries that have jurisdiction over that part of the planet. So I think there are many ways to get involved, to support the kids and the children from the Juliana case that are doing something similar here is a way to start, and also to try to learn more about what is happening in Latin America and to share that information.
Gracias.
Thank you. Let me remind, I neglected to send out the message about the ground rules. I'll quote Josh Galprin from earlier. Questions should be more like a tweet than a Facebook page, Facebook posting. So let's keep it, we only have 10 minutes. We started late for Q&A, so let's keep it moving. Next, hands? Other questions? No questions? Okay, right there.
Okay, my question is simple. When these cases go to trial, would you prefer they be tried before a judge or tried before a jury?
A judge or a panel of people who aren't judges?
We don't have juries in Colombia, so the only option we had is a judge, and that's my answer. We don't have that kind of system there, so I think judges are real people. You know, what happened in our case is the week before the Supreme Court took the decision was the Holy Week, you say so? Easter, and we had a real damage on one of the main rivers in Colombia. And the court quotes the Pope and the message the Pope has on protecting our common home. So I think they're real people with real concerns, and I think that its decision was good, but I don't know how would that be if we had a jury system.
Other questions? Over there.
Hi, this is a question for anyone on the panel. I'm curious how you see litigation fitting into what needs to be happening in the political sphere in terms of actual policy creation. In many ways, it seems like this litigation is kind of happening too late for the gravity of the problem. And I was wondering if you see it having a role in actually leading to things that will change in the government and in policy generally.
Dina, do you want to?
Yeah, well, I think I started to mention a little bit how, for example, in the wave of these liability suits against fossil fuel companies, Exxon is pushing for a carbon pricing mechanism and lobbying for it. So I think, like what I was discussing a little bit in terms of prods and pleas, ultimately having this litigation puts the pressure forward to encourage the greatest emitters to come to the table and negotiate policy, and to also shape the public consciousness so that voters would demand a solution that feels more just and federal policy. And when we think back to the Obama administration and Waxman-Markey and the federal climate legislation we tried to get passed, the idea of like regulatory implementation was kind of the hammer if we couldn't get the national legislation. So I think you have all these different pieces moving between in the judiciary, through the executive branch, through Congress, and they all kind of have to work together and put pressure. If you can't get something through one place, you move through the other. So they're definitely all interrelated.
How do you all see the role of litigation with social movement? Or do you? Do those two things come together?
It was a case brought by civil society. So if you don't have the support of the communities that live in the Amazon rainforest, of the youth, maybe the case wouldn't be successful. So I think for these matters of climate change and climate justice, you need to have the support of the people who are most vulnerable.
Oh, I'd say, you think back to the civil rights movement, and definitely social movements and litigation can co-shape each other. And I think, if Julie were here, I'm sure she'd say by kind of giving and also in these cases internationally where you have youth plaintiffs, I think that makes climate change a much more tangible problem. When you think about this will affect my child, which is something we've always had trouble with the climate change problem. It always seems like this great big problem out there further down the road, not affecting my neighbor, whereas other sorts of social movements have been more tangible for people. So I think as far as litigation and social movements co-shaping, that's a really promising development.
The critique, though, is that a loss in the courts can deflate social movements, it can distract attention from social movements, and that the expertise that's involved in going to the courts can undermine the leadership of social movements. Do you think any of that critique holds water? And then I'll go to the question there.
I mean, it's less than ideal. You don't want to have to force this through the courts, right? And you want to be considerate of what time you're bringing these cases and strategic with the changing composition of the Supreme Court. It's a little worrisome to think about some of these cases working their way up through the system right now. So I think that's always a concern, but we haven't been seeing the kind of progress at the rate we need to see it from the federal government. So I don't know if it's, there are certainly drawbacks, but I don't know what other options we have at this point.
All hands on deck.
I'm asking this question from someone who comes from social movements or grassroots organizations. And so for any of you all, for the cases that you presented, how are they being resourced?
Well, the Justicia is a think tank that its resources come from international cooperation. So basically, that is our resources.
Others?
Others?
No.
Do you know how some of the...
I mean, I would imagine a lot of these cases are, Earth Justice litigates in a lot of places in this space, and you might know more than I do about how some of those are funded, but considering how many of these cases are brought by NGOs, I mean, it's somewhat reliant on their funding streams, and I think the promise of a big win in court, potentially. I don't know how much other donors are involved. Do you know anything from your time at Earth Justice? Do you know anything about how?
I mean, not being specific to Earth Justice, but the big NGOs that litigate, whether it's NRDC or Earth Justice, they have diverse funding mechanisms that they've cultivated over a long period of time. They generally don't take government money. They get some foundation money. They work very hard to get individual donations and cultivate from small donors to bigger donors. They get some attorney's fees when they win cases, although they generally don't budget based on those attorney's fees. They might get grants from sources other than foundations as well. And costs, if say Earth Justice is representing NRDC or some other NGO, that NGO may pay the out-of-pocket costs. So it depends, the specifics may depend on who's bringing the case. But that's the general answer, I would say. Yeah. Back there.
Thank you. Briefly, forgive me, but I'm not a legal scholar, and there are some things I'm not entirely sure I understand. What could really prevent the Juliana case for going to trial? It seems to me, from an external perspective, that the forces that are actually preventing it from perhaps going to trial are forces that, maybe come from all branches of government that should not have this capacity to influence that at that stage. So they seem to be a little bit too powerful there, and that would potentially prevent a case like Juliana from going to trial. So is there a problem, or what is this problem? Is that a problem of separation of powers, or what exactly is the problem, and what would be the ways to prevent it? And I suppose that many of us here would like to see that case going to trial.
Let me break that question up into two, and Dina, I don't know if you want to answer that. One is, what are some of the reasons a case like Juliana might not get to trial, the procedural barriers or whatever? And the second is, do the kind of larger political forces play a role in that? It was a great question, or questions.
So it's sort of like being cold called, I feel like, in law school class again with like, what are the specifics of the case?
No.
But I think what you're raising about separation of powers is a concern. Like, the courts are loath to kind of intervene sometimes in this space when you're trying to get a systemic solution. And then there are a lot more in the weeds legal issues with cases like this that really push the envelope. And I don't know that in front of this audience I want to get into all of the weeds right here, but maybe we can chat afterwards.
Can I add
Yeah,
to that?
please.
To take the moderator's hat off for just a second. Access to the courts is a huge issue in the United States, quite aside from the politics of the Juliana case or climate change, or not quite aside. Access to the courts for issues of justice have been closing for the last 20, 30 years. And questions of who can go to court, which we call standing, questions of ripeness, either you're too early or too late. Either it's not ripe or it's moot. Questions of whether or not a court, what Dina was talking about is justiciability, whether it should be in another branch of government. All of these have been building in the courts for a really long time. It's not just number 45. It is, over time, the repopulation of the courts with a whole different philosophy, and that make it extremely difficult, particularly to go to federal court, to have your case heard. So before you get to have your case heard, you get these motions to dismiss that you don't have standing, it's not ripe, it's moot, it's not in the right venue, whatever it might be. You don't have a right of action. There's no private right of action, whatever it might be. And we've been struggling with those issues. And then you add on top of it some of the particulars here, and you get what did you call it? A wicked something.
Super wicked problem.
A super wicked
problem.
a super wicked legal problem. So, yeah. Okay, one more question, and then I'm going to pitch the last question. One more? Okay, so here's your last question. What do you expect from climate litigation in the coming year, and is there anything hopeful that we can hang our hat on here?
I hope the government becomes fully aware that there's a problem related to climate change, and maybe that will stop climate change litigation. And I feel that would be a good sign, but I hope that media and judges start to understand the complexity of this problem, and that it is real, that it seems really abstract, but it is real, and advocacy is much more than litigation. So I hope we get to understand that.
Maybe just to add something to Gabriela's point of view, I hope that the private sector also starts taking action, and even because of the threats of the litigation, I think it's a potential also. Even if we cannot go much further with the litigation, with the courts, but the threat to litigation may bring some good results in among those stakeholders, the private sector.
I think one thing that'll be really interesting to watch in the deregulation cases is, as rules are finalized, how the litigation pans out, challenging those final rules that the Trump administration is putting forward to try to water down climate protections, and to also keep an eye on these suits by municipalities and counties in the state of Rhode Island against the fossil fuel companies. And if you could start to get those cases advancing or a positive decision, the upwelling of further cases that would follow that could be huge. So I think those are going to be really interesting trends to track over the next year.
So I'm hearing a bulwark against deregulation, advancing the dialogue, helping to mobilize people, and perhaps, and you've already done this, scoring some wins to advance the fight against climate change. That's a lot to inspire us. I want to thank our panelists who have already made a difference, thank the organizers again who have just done a phenomenal job, and thank all of you.
Thank you.
Organizers, do you have any announcements?
Thank you so much for this amazing panel. Everything was amazing and so inspiring. We'll be having a closing keynote soon in about 5 minutes. So if you need to go to the restroom or anything.
Dina, I'm sorry. Hi, good. I'm Aaron. I've been wanting to talk to you for a while because I'm thinking about law school next year and thinking about the dual degree program in particular and interested in basically everything that you're doing. I would love to, set up a phone call or something if you're.
I can give you a business card when I have my first, or you can find my email on the Sabin Center website.
Awesome.
Too.
Yeah, I'll send you an email.
Are you at the forestry school right now?
No, so I'm working. I was on one of the panels. I work at this organization called Communities Responding to Extreme Weather, doing community organizing for adaptation and resilience.
Well, I'd love to hear more about that.
Yeah, definitely.
Yeah.
We can connect.
I'm trying to do more of the adaptation work at Sabin Center.
Oh, awesome. So. Yeah, well, I'm a huge fan of the Sabin Center's adaptation work as well, which is also part of why I was hoping to talk to you. Yeah. Great. Well, I will shoot you an email.
Yeah, are you sticking around for the reception?
Unfortunately not. We're meeting with some real divest students.
Yeah, well then I'll see your name so that I'll recognize it in the
yes.
email.
I will remind you, yeah. Well, thanks so much. Yeah, and this was really super interesting and inspiring. Thank you for all the work you did. tool.
Hello, everyone. Sorry, we'll soon have a cocktail and you can all resume conversation, but if you can sit down for our closing keynote. Sure, if you can get a glass of water for him, that would be great. I'll ask him to stand here. Okay, Commissioner Roberto Cadiz is the focal commissioner for Sustainable Development Goals, International Humanitarian Law, Peace, Environment, Business, and Human Rights of the Commission on Human Rights of the Republic of the Philippines. Currently, Commissioner Cadiz oversees the Commission's Center for Crisis, Conflict, and Humanitarian Rights, as well as Human Rights Education and Promotion Office. He is also presently handling the National Inquiry on Climate Change and its impact on human rights, the first of its kind in the world, stemming from a petition filed before a national human rights institution where climate change is couched within a human rights framework. So all please welcome and joining Commissioner Cadiz.
Thank you very much, Anna. First of all, I would like to thank the Yale School of Forestry and Environmental Studies, the Yale School of Law, the Southeast Asia Studies Center at the Macmillan Center of International Studies, and the organizers of this wonderful event, the 2019 NDEL conference, for allowing me to share in your beautiful campus some of the work that we do within our commission in regard to environmental law and human rights. Special thanks to Anna and Dean Indyberg and the Assistant Dean, Thomas Isley. Are they here? You said they might not be here. Anyway. Thanks to Anna, who invited me in the middle of last year. Was that? Remember what month? Anyways, can't recall it. When I spoke in Colombia and made an early invite. Good afternoon, friends. I've been invited to talk on a case that we are handling within our commission. It is the first case to have been accepted by an NHRI, by a National Human Rights Institution, for investigation, which frames climate change as a human rights issue. This is actually the second case to have been framed. The first case was a case filed by the Inuits before the Inter-American Commission on Human Rights, but it was rejected by that commission. Saying that the facts presented by the Inuits were not within the purview of the rights stated under the organization, the mandate for investigation of the Organization of American States, Commission on Human Rights. It said that the information provided by the Inuits does not enable the Commission to determine whether the alleged facts would tend to characterize a violation of rights protected by the American Declaration. So the petition before us is the second attempt to frame climate change as a human rights issue. And the first to be accepted for investigation by an NHRI. The claim of petitioners is very simple. It says that the human rights of the Filipino people are being adversely impacted by climate change. And the top oil producers of the world have contributed and continue to contribute to this phenomenon. The petition praised our commission for a finding of responsibility on the part of the respondents for such negative impacts, which the petition claims amounted to a violation of their human rights. The choice of the Philippines as a venue for the petition was made significant by the fact that our country was the immediate past chair of the Climate Vulnerable Forum at the time of filing of that case. The Philippines is also visited by 20 to 22 typhoons every year. In 2013, our country had the misfortune of being battered by the strongest typhoon in recorded history to have made landfall. Internationally named Haiyan, locally we called it Yolanda, which caused the death of at least 6,000 people within just a few hours from landfall. When our commission accepted the petition, there was no legal precedent to help it navigate through the case. As I said earlier, the first attempt was dismissed by the Organization of American States, the first attempt made by the Inuits. When we accepted the case also, we lacked the resources to handle a case of that magnitude. Indeed, following the refusal of the Inter-American Commission on Human Rights to hear the case of the Inuits in 2005, nobody would have questioned us had we similarly decided to dismiss the petition. Previous to the filing of the climate change petition before our commission, a long line of climate cases, as many environmental lawyers would know, have been brought, and much more are being brought today, by various parties before regular courts in different jurisdictions. Private citizens are suing governments, governments are suing carbon majors, citizens are suing both governments and carbon majors, regulators and shareholders are suing their corporations. All these under different legal theories of responsibilities and liabilities, such as those involving tort, a civil wrong consisting of a breach of duty resulting to an injury. Many of the cases filed, especially here in the United States, are tort-based cases. In the midst of all this, governments have also been coming together in meetings and conferences to forge agreements, ostensibly to avert the scenario of irreversible global warming, as warned by the IPCC. As we all know, the conference of parties are not progressing as they should, to put it kindly. And other than the clear trend that more climate-related cases are being filed in courts every year, there seems to be no established pattern or direction as to how these cases are being or will be resolved. Many of these cases are still undergoing trial or on appeal. To add to all the foregoing efforts, all these cases being filed, governments coming together to hopefully to come into an agreement, attempts have been made to explore state-based, non-judicial mechanisms for addressing the challenges presented by climate change, such as by framing it as a human rights case and filing it before a human rights institution, such as our commission, and thus the case before us. let me talk about the process that we have decided to engage in the handling of the case. The inquisitorial process, which our commission embarked on, may interest other national human rights institutions in the investigation of human rights cases with transboundary character. We decided that our process would be dialogical rather than adversarial. And recognizing that climate change is indeed a worldwide phenomenon, we also decided that in this particular instance, the dialogue that we would be pursuing would be global. Having declared our intention to infuse a global dimension to our processes, we received many amici briefs, friendly discussions, and other submissions from environmental advocates, legal and scientific experts, and the academe from around the globe. On our own, we invited local and international resource persons to share their knowledge and experience on climate mitigation and adaptation, as well as their opinions on the various dimensions surrounding the issue of climate justice. Local and foreign experts were presented by petitioners before us, of course, together with Filipino victims of climate change. Not too surprisingly, our inquiry garnered the attention of environmentalists, academics, oil companies, and their related industry groups, as well as professional organizations such as the International Bar Association. In myriad ways, also contributing to our process were international human rights bodies and organizations such as the Asia-Pacific Forum, the Global Alliance of National Human Rights Institutions, the United Nations Office of the High Commissioner for Human Rights, and the UN Special Rapporteur on the Environment, to name some. We also received support from institutional agencies such as the European Union through a fund managed by the Spanish aid agency, ACID. All these underscore, I believe, the urgency and importance of climate change as a global issue. Consistent with the global framework which we adopted, aside from those held in Manila, we conducted hearings as well in New York, at the New York Bar Association, and in London, the London School of Economics. We also held consultations in Geneva, in Germany, in the Netherlands, including with experts and lawyers of climate cases, such as the lawyer in the precedent-setting Urgenda cases I believe most of you are familiar with. The oil companies, 47 carbon majors, pleaded in the petition before us, not surprisingly questioned the jurisdiction of our commission to hear the case. We clarified, however, that although we did not have enforcement jurisdiction or compulsory processes against the parties, we had the constitutional mandate or duty to inquire into the matter brought before us. To be sure, we are very aware of our jurisdictional limitations. We have no enforcement jurisdiction, no compulsory processes, certainly not against respondents, majority of whom were not even present in our country. Understanding this, we did not compel any of the respondents to submit before us. We would not be crazy to compel parties not within our jurisdiction to submit before our processes, but rather we invited them to participate in our inquiry. We did not compel them, we invited them. We are also aware that we have no power to impose any kind of punitive judgment against any of the parties. Thus, we announced very early that the determination of damages was not within the purview of our inquiry. Interestingly enough, after we agreed to accept the case, we received information that citizens from several Pacific nations, Fiji and the Solomon Islands, Kiribati, Tuvalu, Vanuatu, also intended to file similar petitions in their respective jurisdictions. Truly, bravery everywhere calls to bravery everywhere, as I read somewhere in Germany during one of our consultations. Our inquiry operated on the principle of persuasion. Thus, as I mentioned earlier, we issued invitations in lieu of summons to the parties. We emphasized, however, that with or without the participation of certain parties, our commission was determined to proceed as it has proceeded with its inquiry in obeisance of its constitutional mandate to investigate all allegations of human rights violations of the Filipino people. We further clarified that our decision to open our processes to the petitioners did not mean that we had already accepted their position, as some people initially thought. The petitioners, of course, still needed to prove their allegations in proceeding that we were determined would be transparent and respectful of the principles of due process. The oil companies asked our commission to dismiss the petition, arguing that the Philippine Constitution allowed us to investigate cases involving civil and political rights, because if you read our Constitution, that is what is stated. It specifically referred only to civil and political rights. And textually, there was a good argument to challenge our decision to hear the case. But we noted that the petition did allege violations of civil and political rights. People were killed. People died during that huge, big typhoon. But more importantly, we explained that all human rights are interrelated, interdependent, and indivisible. We said that one cannot consider civil and political rights separately from economic, social, and cultural rights. Such is humankind's evolving understanding and consciousness of human rights. We were ready to be challenged in the Supreme Court and show to that supreme judicial body of our country that it is time to revisit the interpretation of the mandate of our commission. In the conduct of our public hearings, we have sought to maintain our focus on the substantive aspects of the case, not to be waylaid by or lost on technical issues. This is not to say that we disregarded internationally recognized norms of substantive due process. We have given every opportunity to all parties to participate in our processes. Respondents were duly notified of the petition filed before us and were enjoined to participate in our hearings. We received testimonies and documentary evidence in a very organized manner. All our hearings were transparent and public, even cast live over the internet. You can even view it now if you Google, if you go to YouTube. Witnesses were properly sworn, and after their direct testimonies, were offered for cross-examination to parties. Documentary exhibits were properly marked and identified. We offered to engage in special meetings with respondents if that was what it would take for them to present their position on the issues brought against them before us. Our visits to the US, to England, and the Netherlands were not only a matter of underscoring the global dialogue that we sought to pursue, but also a matter of due process. we have endeavored to make it easier for respondents in those parts of the globe to engage in our process. We have conducted a total of 12 public hearings from March to December of 2018. 8 of the hearings were held in Manila, 2 were in New York, and another 2 in London. We have admitted 239 documentary exhibits consisting of more than 1,000 pages and heard 65 witnesses. And these do not even include the resource persons invited by the Commission itself and the pieces of documentary evidence that have been submitted by our own resource persons. These are on top of the consultation meetings, site visitations, community dialogues, roundtable discussions, and key informant interviews conducted by our inquiry panel. In April of this year, we shall be holding our final consultation with mostly academics in the University of Stirling, preparatory to the drafting of our Commission's inquiry report, which we hope to be able to release sometime within the middle of this year. Our findings will be informed by science and may be considered by courts of law, as well as political branches of government, wherever they might be deemed relevant. In our report, we hope to be able to identify basic rights and duties relative to climate change, as well as to clarify standards for corporate behavior, among others. So just let me share a few themes that will be covered in our report. First, climate change is a justice issue, especially as its negative impacts are significantly greater on those who contribute less to it, and vice versa. Climate change is indeed an existential issue, not in the mere philosophical sense of the meaning of life, which are leisurely discussed in coffee shops, but in the concrete sense of threatened human existence, which calls for urgent action. Climate change is a human rights issue. Its negative impacts on the right to life, food, water, health, and other civil, political, economic, social, cultural rights are now writ all over the globe. I also wish to emphasize the role of national human rights institutions in the fulfillment of their mandates. The challenge to national human rights institutions is to test boundaries and create new paths, to be bold and creative instead of timid and docile, to be more idealistic and less pragmatic, to promote soft laws into becoming hard laws, to be able to see beyond legal technicalities and establish guiding principles that can later become binding treaties. In sum, to set the bar of human rights protection to higher standards. At the end of the day, the outcome of our inquiry will be judged by the fairness and inclusivity of our process and by the evidence on which our findings and recommendations will be based. We hope that we have shown a model for the broadening of mechanisms and processes for helping address grave human rights challenges, especially those imbued with transboundary character, such as that of climate change. Let me end on a positive note. Throughout our inquiry, our travels, our consultations, I have seen the energy of the younger generation. I have seen their amazing, highly evolved consciousness and commitment to the preservation of our environment for themselves and the future generations, which shames us, the older generation. This gives us hope. Thank you very much.
Hi, everyone who's still here. Thank you so much for being a part of this wonderful day of discussions. My name's Emma Legel. I'm one of the chairs of NDEL. I just want to reiterate our thanks to everyone who made today possible, from the FES and YLS administrative staff, IT and building facilities who allowed us to be here on a Saturday, Josh Galperin, who was such a help in kind of accessing a lot of the speakers, and all of our donors, every panelist who came from across the world, from the Philippines, Nepal, Pakistan, all throughout the United States, South America, all of our volunteers who have helped today run as smoothly as possible, our amazing panel organizers, Akari, Addison, Yoni, Athena, and Saskia, and then my fellow board members, Emma, Andrea, and Anna, and Camila. I was like, I'm forgetting someone. We didn't write your name here. Okay, thank you.
Thanks, Emma. I just want to thank again everyone, and I think everyone today heard something they liked, and I think everyone today heard something they might not have liked. And I was thinking about this, you know, and the tensions of how we define justice and equity, and I was excited about that. I'm excited that we don't agree, all of us in this room, and I think we agree that climate change is happening and that we need to do something, but the solutions presented today were diverse. The speakers were diverse, the positions were diverse, and diversity is not just a buzzword. It's not just something that looks good and that we, you know, like put hashtag diversity and then that's it, and we have, you know, equality. We all know it's more complicated than that, but I think I speak for the board when I say we loved having all of the people that came here today and made it a different sort of environmental movement, a different sort of climate movement, and I'm just excited to see what keeps happening in the following year. So thank you again for being here.
And I'll be the final one to thank everyone for coming. It's been an amazing day. It's a culmination of basically years of work on our part. You know, since last year's conference, we've been working. And yeah, we'd like to invite everyone to have cocktails outside. We're all set up, and to mingle and talk about the day and share ideas. Thank you so much.
Ran through them. There's 2 thumb drives up here in the computer. I don't know if those belong. Oh, one's Dina's. Okay. And the other one. Okay.